Good day. Thank you very much for being part of this presentation. Where we are looking at a basic outline of a Bachelor of Laws degree. Now, you will notice that each university tends to have its own structure. There are many universities in South Africa, and each university approaches this Bachelor of Laws degree in its own unique way. So what we are going to discuss here is just a basic outline. We are not saying that all universities follow this format, but at least you will expect that one way or another, you are going to encounter one of these subjects, maybe framed or named in one way or another, different from the way the naming would go from one university to the next. But basically, we expect that a lawyer would have at least studied one or all of these, subjects, even if they are named differently, but at least one would have encountered them, maybe with others that are not featured here, depending on how that particular university is structured. So it's a basic outline of a Bachelor of Laws degree. And what we have here, maybe as a point of departure, let me emphasize that this course would be designed to teach skills and content. Each course, whether you approach one university or the other, should at least teach you both skills as well as content. You see, there are skills that are peculiar to lawyers. You must develop those. There are quite a number of them. For instance, you've got your oral skills, your ability to talk and to argue and present issues. Then you've got your writing skills, which actually are linked to your research skills, interview skills, inquiry, that ability to conduct an inquiry, to conduct an interview with a client or a witness. So there are skills that really one has to develop. Even the skills of litigation and presentation of matters in the court. So all those are very, very important skills that one has to develop as a lawyer. And still talking about this subject, you must remember also that in looking at the subjects, we are going to, I'm going to just give you a rundown of some of the subjects, and you will notice that some subjects are requisites of others. In other words, there are subjects that you must learn early, and there are subjects that you must learn later. That is after you've acquired some basic skills in terms of the other subjects. For instance, if you can take a subject like a criminal procedure, you naturally have to study criminal procedure after you've understood principles of criminal law, because criminal procedure applies a lot of principles of criminal law, which basically means that if you do not yet fully understand, or if you don't have an idea about criminal law principles, you may find it very difficult to understand what we mean by criminal procedure and so on. So in this particular case, then we are saying that principles of criminal law as a subject serves as a prerequisite for, it's a prerequisite for the study of criminal law is a prerequisite for the study of criminal procedure. So we are saying some subjects provide a foundation for an understanding of others. Having said that, one, you may have to develop skills and you must learn content. You notice that a well-rounded jurist is one who has an understanding of skills as well as a grasp of the concept of the content, the substantive law itself, those principles, an ability to explain the rights and so on and so forth. Yes, that's very important. So you find that there are subjects such as to do with language, African language. Remember, you are going to be practicing law within an African setup. So your understanding of African languages, if you are operating in South Africa, is very important. Most of your clients, most of your witnesses are going to be speaking one African language or the other. It could be isiZulu, isiXhosa, isiSwati, isiNdebele, iSpedi, or Sesotho, or Tshivenda, isiTsonga, and so on. So you may then have to, whilst you are studying law, also try and develop a grasp or an understanding of African languages and how they affect our understanding of the law in its daily usage and proper usage, that kind of thing. So that's as far as language is concerned. You may ask yourself a very, a question to say, but if I am being trained to be a lawyer, what is the point in me maybe seeking an understanding of financial accounting? You will understand that a lawyer must understand financial accounting. As a lawyer, you are going to be handling other people's monies. You are going to be handling trust funds. So you are going to be running that practice. And it is very important for the practice as you run it that you fully grasp and fully apply those important principles of financial management. So if you don't understand finance, how are you going to be handling trust accounts and the business accounts of the legal practice? You understand? So you can't escape it. We had to talk about this one from the onset because there's often a misnomer or a thinking that lawyers don't need to understand any principles of account, and that's not true. So get ready, start working on your numbers if you were not very good with them. This gone are the days when it used to be said that lawyers don't need to be conversant with numbers. It's a thing of the past. In fact, it was never true even in the past. So make up your mind that you are going to start working on it. If you have a problem with numbers, then you may have to start very early. Understand those financial accounting principles. You are going to be reading this together. It's part of your practice. As you practice the law, you'll be using this, you'll be applying this on a daily basis. And then another interesting subject is the historical foundations of South African law. You know that South African law is very diverse. Its origins, there are principles of South African law which originated in Rome. And then there are others which originated in the Dutch province. So hence you hear people talk about the Roman Dutch principles of law. And those are, that's the Western component of South African law. Then you have got your human rights, which has been developing as an element of international law. And then you've got your indigenous South African law in the form of what do you call this? Your African customary law, which is part and parcel of the law, if one would say. And then, so there are also other societies like the Indian society, which is a very important element of South African society. They've got their own principles also, principles that apply to the Indian community. And then there are also, members of the Islamic community who also have their own Sharia law or their Islamic law, which affects their day-to-day relationships, including their marriages, their succession, inheritance laws, and so on. So it's very, very important to understand that. Now, all these will come up, as an aspect of an introduction of law, whereby we are saying some of these are very fundamental, that we must understand issues such as the science of law. What do we mean by the science of law? Where we are looking here at the fact that, law is a science in a way. In starting it, there is a structure, there's a format that you must follow. So all those issues, they constitute a course in themselves. And then you've got your fundamental principles of research methodology rather, for law and criminal justice. We are concerned here about how to research the law, how to find the law, and how to, seek and find solutions to some of the prevailing problems in society, because law is an instrument for the resolution of social problems and society's problems. So it's very important as a lawyer that you know how to research, you know how to apply research methodology, and then you also know how to write a research report at the end of when you've established whatever findings you have. You also have to think about African philosophy. Until the end of apartheid, you find that the African law and African ways of thinking were sidelined, so to speak. But if you read there's a paradigmatic case of 1995, the S versus Makwanyane case, those gentlemen who were on a death row. The court reasoned in a very interesting way. And for the first time, African philosophical principles such as Ubuntu were considered by the Constitutional Court. So since that time, you find that our interest in African philosophy has also risen as a result. Then you've got your law of persons. The law of persons is also a very important subject. What do we mean by law of persons? It's that law that deals with the identification of who is a legal subject. How does one acquire the rights of, how does one become a legal subject? Who is a legal subject? Yes, that's the question. How does one become a legal subject? What are the rights of that legal subject? What are the competencies of that legal subject? So, issues of status, what status one has in law, what can one do, and what is it that one is not capable of doing, or what one is not competent to do in law. So all that is very, very important. Well, as I alluded to earlier on, when I asked the question whether a course should emphasize content or skill, you find that there are certain skills that a law student must develop. That's very, very important for you to develop and to think about. We spoke about your research skills, your writing skills, your reporting skills, your oral skills. Remember, as a lawyer, you will have to present arguments in court. So your public speaking skills must really be honed so that you are able to confidently articulate whatever your argument and observation might be before a court of law. So that's very, very important. So a skills course is very essential, and you must develop skills in that line. Another important, course or area is the social dimensions of justice. Remember, the law does not only serve the interests of a narrow community, but it serves the interests of a broader community. And we always ask ourselves questions to do with what the purpose is of, practicing law, the rights of the people, how they are enforced, all those issues. So you find that it is not a justice system if it sidelines some people and promotes the interests of others. So thinking about social dimensions of justice, you are thinking of law not only as an instrument through which maybe rights are vindicated and so on, but there's also the issue of whether alternative dispute resolution strategies may be obtained, how eventually the law should serve the interests of the broader community by bringing justice and by bringing harmony and by enabling members of the society to live together, in that mutual existence and be of benefit to one another. So that's very, very important to consider. So that's as far as the social dimensions of justice are concerned, which means you have to study that module or study a course in that area, so that at least we know that we understand how the law affects the relationships between people and how the law can be used to, forge that harmony among people. Well, in studying law, you must understand that there are certain non-legal subjects that you may also have to consider. We are saying they are non-legal in the sense that the lawyer doesn't really directly use these, the knowledge acquired from them in a court, but they are very important to the extent that they help us understand some of, the phenomenon or the concepts that we are dealing with. For instance, talk about criminology, which is the study of crimes, criminals, offenders, and criminal behavior. For instance, this subject would be concerned about who is a criminal, how does one become a criminal, or how does society define certain conduct as a crime. Is there anyone called a criminal? Is there anything called a crime in itself? Some people would argue that there's nothing called a crime or inherently criminal in itself, but crimes are behaviors that are condemned by society. So then we ask ourselves or inquire into the process of establishing what is what conduct gets to be defined by a certain society as a crime, whilst maybe in another society they might not even think of it as a crime. So you study therefore criminology, you study victims, how are victims treated and accommodated back to society, and treated, how they are given protection, and all the interventions maybe to mitigate the effect of the crime committed upon them. And of course, we have already spoken earlier on about the issue of multilingualism and the role of language in South African context. You find that as you seek to understand maybe the importance of the various South African languages, it's not so much a case of you studying law, but you'll be studying if it's Tsonga or isiZulu, whatever. That language is not law in itself. but our maybe grasp of that language would enhance our effectiveness within the communities where we operate. So that on its own also gets to be very important. As you will remember, I said that these are non-legal subjects. In other words, they are not hardcore legal subjects that you would find as in all other LLB degrees or Bachelor of Laws degrees, but an understanding of them is essential, for our operation as lawyers or jurists. As you can see, subjects like criminology tend to border on not on the law as such, as a discipline, but some people might argue that these are elements of sociology. The study of crime and deviance would occupy a sociologist more than it should occupy a jurist or a lawyer. But these are subjects that we need to understand in order to operate effectively as jurists or as lawyers. So we can have a look at some of these subjects that are very, very fundamental to the study of law. Those that one would say are at the backbone. For instance, you would have your what do you call this? Your administrative law. As you can see, that's administrative law there. You will study more and you encounter some of these principles to do with how persons who are affected by maybe the decisions of government organs or organs of state, what rights they have, how they can carry themselves around to protect their rights and so on. So that's as far as administrative law is concerned. Then you've got your principles of criminal law. What is a crime? What are the elements of a crime? How do we arrive at a conclusion that a certain conduct is a crime? So those are some of the things that you think about. And then you got your specific crimes, Then you get when you talk about specific crime, you notice that there are certain actions or conduct that constitute crime. So, for instance, a conduct such as killing of another person, killing of another human being, or taking over property belonging to another person, that conduct is deemed to be a crime. And the question is, what are the features or what are the elements? So you would have to study each of the several conducts that are deemed to be criminal in terms of their elements, in terms of what elements must be satisfied before we can conclude that a certain offense or a certain crime has been committed. And then you have got your constitution, which is the supreme law of the republic. In terms of that constitution, which is the supreme law of the republic, you look at the role of the constitution. What is a constitution? Maybe starting from what is a constitution? What's the role of a constitution? What does it do? How does it affect all other laws? Maybe an interesting observation is that the Constitution of South Africa is a supreme constitution. It claims to be supreme. In fact, it says the Constitution is the supreme law of the Republic. All laws must conform to it. There's no law that should ever be found to contradict the Constitution. So if a law is not consistent with the Constitution, then it is void. Any conduct that is not consistent with the Constitution is void. Then talking about the Constitution, you also find that Chapter 2 of that Constitution is the Bill of Rights. So talking about the Bill of Rights, we are talking about the rights that are enshrined in the Constitution, the rights that people are entitled to in terms of the Constitution. So you can safely say that a study of fundamental human rights is in a way a study of the Constitution of the Republic of South Africa. Then you've got your African customary law. I spoke a little earlier about how indigenous African societies used to exist and how they regulated their relationships prior to the advent of colonization. So you find, for instance, the Zulu people or the Xhosa people or the Tsonga people, the different African communities, they used to have their, they used to have their rules and their systems of running their affairs. So we are concerned about that African, what we call African customary law. It's the law in terms of the customs of African societies as they were applied, as I said, before the advent of colonization in Africa. Then you got your interpretation of statutes. It's very important that when you have sources of law, such as acts of parliament or statutes, there are principles that are applied in interpreting them. So it is very important, and we are going to look at, you will have to study and understand the principles that are applied in the interpretation, or in seeking to understand the meaning of the statutes, the exact position in law. That's as far as the interpretation of rights is concerned, whether you follow a literal approach, a contextual approach, or purposive approach. And there are various maxims and various principles that one has got to apply. So those principles have to be clearly understood, and they are part and parcel of what one has to study. And then you've got entrepreneurial law, or the law as it affects, those in business, the companies, formation of companies, formation of, business entities and organizations. That's as far as entrepreneurial law is concerned. Then you've got your family law, which regulates the relationships between different members of the family, husband, wife, and children. And then that's very, very important. And then you've got your law of succession to do with when one person maybe who was an owner of property passes on, or it could be as a parent. How does property devolve to the next person? So how, for instance, do children inherit from their parents? Do they inherit obligations, responsibilities? What exactly do they inherit? So those are some of the very important principles that one has to understand. So this is just a summary of some of those subjects. You will have to deal with them, with each one of them in greater detail. There are many other subjects, as I've already alluded to, but if you look at what I have here, I have got quite a number of subjects in this bulleted list, and there are three that I have highlighted. They are civil procedure, criminal procedure, as well as the law of evidence. Now, looking at these three subjects, They are what some people may call adjective law. These three. They are adjectival law. They are, they've got to do with the rights. You notice that the rest of the subjects are what we call, they deal with issues that we call substantive law issues. But civil procedure, criminal procedure, and the law of evidence are different from the rest. Why is that the case? It's because they outline the steps that one has got to follow in terms of enforcing their rights, which may have been violated by another person. So they will occupy us. In fact, I already do have a video on substantive law and procedural law or adjectival law. So you may have to follow that one up just for the difference, to establish the difference between substantive law and procedural law. But as I have already said, these three are slightly different from the rest because they don't only tell us what rights we have, but they show us what steps we must take and what material we must provide in order to enforce our rights, which may have lain in jeopardy because maybe there is an infringement by one person or another. Well, so we have got other substantive subjects among them we have your insolvency, your labor law. So we have insolvency law, your labor law, law of property, the law of contract, the law of delict. Now these two, law of property and law, so the law of contract, law of delict, and law of, maybe let me say three, they've got to do with obligations. So the issue of obligations that one may have, maybe the same applies to enrichment and liability as well as estoppel. They've got to do with some obligations that one person may have. One person may owe another. So those are very important subjects. So once you begin to deal with your law of obligations, it goes without saying that your law of patrimony, which is got to do with your property, the law of contract, this is just another obligation, and then the law of delict, another source of obligations, as well as estoppel, enrichment and estoppel, another source of obligations. So these are very, very important laws that you need to fully grasp and understand. Then you've got another set of laws which are very, very important. Let's look at international law. Section 39 of the Constitution of the Republic of South Africa does refer to international law and concludes that it is part of South African law. So it goes without saying that one cannot fully practice law in South Africa if they do not have a working understanding of what we mean by international law and how it affects, how international law affects us, if one would say, or how it affects the practice of law and what rights it enshrines and so on and so forth. And then there's also the issue of, indigenous law. Indigenous law, in a way, is a part and parcel, or one would say it goes hand in glove with the African customary law, whereby we are saying what is the law, what was the law practiced and applied among the various African communities before the advent of Western law? And does it still have any relevance today? Well, you will notice that we have some communities which still live and conduct themselves on the basis of indigenous laws. If you go to most communities in rural South Africa, people still relate on the basis of indigenous law. They still refer matters to their local, indigenous courts run by chiefs and so on. So that is the role of indigenous law in South Africa. And how about the issue of, well, earlier on we spoke about African philosophy. We must understand that there is Western philosophy. So you may understand law from the point of view of African philosophy, as well as from the Western approach of philosophy. So one would say maybe one of the outstanding principles of African philosophy is the philosophy of Ubuntu. How about the Westerners? How do they approach the law? How do they approach justice? Then you may have to be thinking about the works of, those naturalists. But even before you get there, you have people like Plato, people like Socrates, and people like Aristotle. Those early Greek philosophers, how have their ideas affected the way we view the law generally? How about the work of naturalists such as Thomas Aquinas and others? And then you may also be thinking about those early modern philosophers of Europe, the likes of John Locke and the likes of Hobbes and many others. So that's got to do with legal philosophy. Very interesting area, but I know some people find it a little bit tricky, but it's quite enlightening. It at least gives us a background to how the law developed to what it is today. And then you've got your professional ethics. How should a lawyer conduct himself or herself? I'm sure you have heard about some lawyers being deregistered from practice, maybe because they did not conduct themselves in an ethical way. Think about a lawyer who lies deliberately in court, he misleads the court. Or how about a lawyer who abuses trust funds, monies entrusted to her or him by some client, and then that lawyer decides to embezzle that money? How should such people be treated? So that then brings us to some of the issues to do with a fit and a proper person who must practice the law. Is a Bachelor of Laws degree sufficient, or there should be another quality to do with maybe the way one conducts herself in public? Is their conduct above reproach? Are they the kind of person who can practice the law without bringing the profession into disrepute, if one could say? So that's very, very important to think about. And then we also, maybe still this one, when we spoke about entrepreneurial law, it was in reference to something almost of this kind, company law. How does one establish a company? What are the features of a company? How should that company conduct itself? What are its rights? What are its obligations? And so on and so forth. The company as a legal person, even when we spoke about the law of persons, you notice that a company is a juristic person established for that purpose of running. Could be a particular business. So as a juristic person, a company is a person in law, but it's different from a natural person. As I said earlier on, when you study the law of persons, these are some of the things that you come into direct contact with. And then you've got your law of damages, which links very much to the law of delict or tort that we spoke about earlier on when we spoke about obligations. So damages and obligations go hand in glove. You must understand that part. And then Last but not least, you must understand that there are many other branches of law that have emerged in recent years. For instance, environmental law was not always at the top, but lately it has become a very important consideration. So you've got your environmental law. I'm sure you've heard about climate change and how it's very important to, when you are running business or when you are conducting yourself, to consider the environment. You've heard about sources of fuel such as coal, which are said to be destructive to the environment. So environmental law is very, very important to think about. Usually these, in most of these universities, they come as the elective modules. In other words, they are not basic to the main curriculum, but you choose among these just to enhance, your portfolio. And so they are very specialized fields, but as I have said, they are growing very fast. So you got your environmental law, your international human rights law, since the era of the Nuremberg trials in the post-World War II period, the human rights abuses under Adolf Hitler, and how they led even to the adoption of the Universal Declaration of Human Rights in 1948. So since that time, you find that international human rights law has grown by leaps and bounds. You've got your education law for those who are practicing in that area, and then your medical law, very interesting area, especially in the light of recent advances in medical science and technology, organ transplants, with some ethical behavior emerging, where we have some tissue harvesting taking place, people's organs being harvested without their informed consent. In some countries, they just raid a cadaver and take out parts such as the kidneys and the heart without even informing or having, any agreement with the relatives of the deceased. So some ethical issues are arising here. How about issues of maybe the right to be given medical treatment under emergency circumstances? All those are very critical parts of the law. And then we've got your intellectual property law, your patent, your copyright, your design, and your trademarks. Then your private international law, your private criminal law, your medical media law to do with newspapers and television. And then, well, competition and trademarks, maybe I have already alluded to that as a part of the intellectual property. Some people would want tax law to do with taxation, or insurance law. Banking law and usage is another interesting area, depending on if you want to work in the banking sector. You've got your notarial practice too, your conveyancing, your law of sale and lease of properties, as well as the legal aspects of electronic commerce. Well, electronic commerce is very fast growing area. In recent years, the transactions over the internet have proliferated very, very significantly. People are having to buy online. You see, using some of these online stores and transacting electronically using their bank cards, their electronic funds transfers. So there's a lot of commerce taking place in terms of these electronic platforms. And at the same time, you find that a lot of injury is being inflicted. Some people are losing their valuable resources through scams. So those are some of the things. If you are interested in resolving those issues, then legal aspects of electronic commerce are actually your area. In fact, I want to believe that this is a very fast growing area. Anybody who wants to keep abreast with the law would rather, with my suggestion, fall into that area and follow that one very closely. Okay, we've come to the end of our discussion. I certainly hope that you have gained a lot from it. Remember to keep watch over the upcoming videos and follow our WhatsApp group. We've got our A-Class virtual WhatsApp group. If you follow some of my platforms like the Facebook, as well as writing to me at iclassvirtual@gmail.com. And as you regularly visit the YouTube platform, you will see some of the links, especially to the links that I've made there to do with the WhatsApp group. Please remember to click on those, join the group, and join the ever-growing community. See you next time. Have a good day. Bye-bye.